Hi, I'm Alexander Haberbush, president of the Lex Rex Institute and a practicing attorney in the area of constitutional law. And this is the newest entry in our video series, Ask an Attorney, where I answer unscripted questions from you, the audience, about matters pertaining to constitutional and related areas of law. So without further ado, I'd like to jump into today's question. Okay, so today I've been asked, I've been seeing in the news that some people are urging Clarence Thomas to resign because he didn't recuse himself in a case that involved his wife somehow. Under what circumstances are justices supposed to recuse themselves? What happens if they don't? Okay, that's an interesting question. Before I get into the substance of that question, I just want to talk about what exactly is meant by some of the phrases that are used in it. So, what recusal means is that a judge has abstained from participating in a case. He's going to hear no part of it. He's not going to render judgment on it. For a lower court judge, a lot of lower courts tend to be only one judge hearing a case. What that means, practically speaking, is that the case would go to a different judge. For the Supreme Court, where there are 9 justices, if one of them recuses himself or herself, what that means is that the remaining 8 justices hear that case. We've actually had instances where as many as 3 justices recuse themselves on a case, in which case the remaining 6 justices hear the case. But theoretically, even more than that could recuse themselves if the circumstances called for it. So what sorts of circumstances do call? Well, and also, before I move on, related concept is that of judicial disqualification. So if a judge refuses to recuse himself on a case where he really should have, that can be appealed by the party that feels that they were treated unfairly by that failure of a judge to recuse himself. And then a higher magistrate, so a higher tribunal, will compel that judge to recuse himself, and then they'll remand that matter to be heard by a different judge. So related issues, recusal is sort of the voluntary one, and that's the one we're talking about today. So what sort of circumstances call for a judge to recuse himself? Well, typically partiality. Bias, something that would suggest that judge has an interest in the outcome of the case that would affect his ability to exercise unbiased, cool, dispassionate reasoning. So what would make somebody assume that about Clarence Thomas with the Supreme Court's recent caseload? Well, to answer that, let's take a quick look at the text messages that were sent by Clarence Thomas's wife, Ginny Thomas, to then White House Chief of Staff Mark Meadows. So this is sort of a text message that was sent to him to sort of help encourage him in some of the litigation pertaining to the challenges of the 2020 election. So what Ginny Thomas said was, "Help this great president stand firm, Mark. You are the leader with him who is standing for America's constitutional governance at the precipice. The majority knows Biden and the left is attempting the greatest heist of our history." She also said, "Release the Kraken and save us from the left taking America down. And I can't see Americans following the obvious fraud." So as you can see, these text messages sort of allege that there was fraud that occurred in the 2020 election. Very politically charged. Here, I'll pull them up again. Very politically charged. She says, "Release the Kraken and save us from the left taking down America." Well, obviously, left is a political faction. That's an overtly political comment. Court is supposed to be an apolitical body. So some people have said that these text messages raise some issues with respect to Justice Thomas's impartiality. Specifically, they raise these issues with respect to the Supreme Court case that was recently went across the judicial calendar, which was Texas v. Pennsylvania. That was actually a case on which I was heavily involved, in which Texas challenged some of the procedures from several other states, Pennsylvania among them. We'll get to that in a bit. But before we get there, I want to talk about the circumstances in which it's appropriate for a judge to recuse himself. So, why do we require recusal at all? Well, to start off with, we do assume that judges are impartial. Part of the job of what a judge does requires impartiality. This dates back really to time immemorial. It's something that's been in our legal history since as long as there were laws. You find it even in the Mosaic Code of the Old Testament Hebrews, that judges were supposed to be people who were disinterested in their cases, people who would not be susceptible to a bribe. In fact, it says people who hate a bribe. And today, all judges, when they take office, swear an oath to uphold the Constitution and apply the law impartially. In fact, the integrity of our republic requires that we trust them to live up to that promise. Because if they don't live up to that promise, they're no different from the politically elected branches of government. Now, oftentimes we will fling all kinds of accusations at the Supreme Court for being, partisan as all get all, but and oftentimes, those allegations may be warranted. But we do need to accept for our republic to continue to exist that judges are at least supposed to be acting impartially when they hear a case. And I do think that most of the Supreme Court justices do attempt to impartially apply the standards of the law to cases. They just have very, very different judicial philosophies. And sometimes those philosophies can look an awful lot like their partisan views. But we're not going to get into that too much today. That's a topic for a different video if anybody wants to ask about that for a future video. But anyway, all that to say, because of this assumption about judges, there is a presumption under, an evidentiary presumption of honesty and integrity from judges. In other words, if you want to challenge the partiality of a judge, the burden of proof is on you. You're the one who has to make the case because we're going to assume that judges are impartial unless shown otherwise. This can be traced way back to the common law rules about judicial recusal / disqualification. And essentially it goes back to the maxim that no man may be a judge in his own case because his interest, and Madison in Federalist Number 10 quotes this and says, because his interest would certainly bias his judgment and not improbably corrupt his integrity. So again, all of the rules relating to recusal trace back to this maxim that no man may be a judge in his own case. In other words, are you actually at trial in this case when you render judgment to the parties in the case? Originally, this maxim comes from Sir Edward Coke, and it comes from a very famous case, Dr. Bonham's case, which is a case, I don't remember the exact year, but it was heard definitely during the Elizabethan rule, Elizabeth I in England, so it's very, very old precedent. And that's where that maxim is first established, that no man may be a judge in his own case. Interestingly, that case was also one that debatably established the idea of judicial review. Coke referred to the idea that the common law can control acts of Parliament. So in other words, laws, the established laws of England can rein in or control the acts that Parliament is trying to pass. So what would that do? That would give judges the capacity to then look at laws Parliament had passed and then judge them. It's actually one of the cases that was used by the American colonists in 1775, 1776 as justification for nullifying the Stamp Act, which, if you'll remember your history classes, was one of the principal causes behind the Declaration of Independence. So very, very important case in our history, and significantly, it is the case that establishes this rule about judicial recusal. Now, under the common law, so this is prior to the United States separating from Great Britain and certainly prior to the Constitution in 1787, recusal was understood to apply to cases in which judges had a direct, personal, substantial, and importantly, pecuniary interest. So direct, personal, substantial, pecuniary interests were what required disqualification. Now, what's a pecuniary interest? That just means an interest that relates to money, either making money or losing money, because that's a harm you can actually quantify. People may have their feelings hurt by all kinds of things, but if you lose $20 from something, we can point to that $20 and say you were actually harmed by it. So pecuniary harms tend to be the harms most commonly recognized by law. We see that again being the case here. So that's the law that existed prior to the ratification of the United States Constitution. So how does the Constitution then modify the standards pertaining to judicial disqualification / recusal? Well, if you remember what I've said about the Bill of Rights in the past, the Constitution of the United States, and this is widely accepted point of judicial jurisprudence, is that the Constitution of the United States in no instances gives American citizens fewer protections than they had under the British Constitution. So we know that the protections given, in other words, the standards whereby a judge is required to recuse himself from a case, cannot be lower. I'm sorry. The Constitution protects at least that much. So it may protect more. There may be more circumstances in which a judge is required to recuse himself from a case, but at least that's the minimum threshold that we know the Constitution must protect. Now, as we've also said in the past, our Constitution is a document of enumerated powers, and also, to a lesser extent, but still is the case, it's a document of enumerated rights or prohibitions on the Congress. So where in the Constitution do we find this idea that judges need to be impartial, or that they're required to recuse themselves from cases where they have an interest? Well, it's actually in the Fifth Amendment Due Process Clause and the 14th Amendment Due Process Clause. Both of these amendments have a due process clause. They do somewhat distinct things, but that's probably not directly the purview of today's question. But anyway, you find that requirement in the due process clauses of the Constitution, because a fair trial and a fair tribunal is a basic requirement of due process. That was said directly in the case FTC v. Cement Institute, a 1948 case. And that's been widely recognized throughout all of our history. Fair trial and fair tribunal is a basic requirement of due process. Now, why is that? Well, what is due process? Just looking at the phrase itself, it is the process that you are due as a citizen. Well, what's process? That's all the different steps you have to go through in order for a court to deprive you of any interest that you have. So due process would include things like a right to a trial by jury. It would include things like requirement for criminal crimes, a requirement of proof beyond a reasonable doubt. All of these different sorts of things are requirements of due process. And we know that the impartiality of a judge, which necessarily requires that in some instances they recuse themselves or be disqualified, we know that that was an element of due process because it's one that was protected under the common law. Looking back all the way to that Elizabethan ruling in Dr. Bonham's case, we know that it's been true since then that was a requirement of due process under the British Constitution, so it must continue to be a requirement of due process today. Now, it's noteworthy that under the Constitution we recognize a few other things in addition to the sorts of harms to pecuniary interests that we mentioned earlier. For instance, threshold is higher when a judge has publicly commented on a matter prior to hearing it. This is actually what happened when Scalia had commented, late Justice Scalia had commented about the phrase "under God" in the Pledge of Allegiance. He'd said that he thought that case was totally without merit, and then lo and behold, that case ends up going before the Supreme Court. So Justice Scalia ends up recusing himself from that. I'm not saying that's constitutionally required, but there is a higher standard that has to be met when there have been comments made away from the bench. Also, another standard that may have been incorporated into the Constitution is close relationship. So, if you're a judge and your daughter is a party to a case, like your daughter is somebody being sued, you probably shouldn't hear that case. You can probably be presumed to have a bias, even though you won't directly financially benefit or be harmed by the outcome of that case. You got a close relationship with your daughter. You don't want your daughter to be harmed, so we often extend it to that as well. Now, one of the most significant cases interpreting this idea of disqualification is the case Tumney v. Ohio. It's a 1927 case. And that case said that judges, that case is a prohibition case, 1927, and that looked at an Ohio law that essentially rewarded judges if they found people guilty for certain prohibition-related offenses, which, you can probably see the problem already, creates a perverse interest for judges to put instrumentalities and systems in place that will find defendants to be guilty, because they are directly getting rewarded when they find a defendant guilty. Now, that you may say, well, that's a pecuniary interest. The judge is making money off that case. That's exactly the sort of thing that's addressed in the common law. Well, not quite, because the common law rule pertains to pecuniary interests in the outcome of a case. In other words, by ruling a particular way, I am deriving a financial benefit or receiving a financial harm. The outcome of the case is that somebody goes to jail or gets a civil penalty, or criminal penalty, or whatever the case may be. So whatever the criminal penalty is to that case. But the court said that because the judge was receiving a financial reward for his ruling, even though it wasn't a consequence of the ruling itself, it was sufficient to result in a disqualification of a judge. And because it applied to all the judges in Ohio, It meant that all the judges had to recuse themselves. Or, I'm sorry, you can't have all the judges recuse themselves, obviously. So it meant that the law was unconstitutional. Now, it's significant to note that constitutionally speaking, personal bias or prejudice alone are never sufficient as a basis for imposing a constitutional requirement of recusal. So what does that mean? What that means is that the mere fact that somebody appears to be biased on something isn't enough to say that the Constitution requires them to recuse themselves. Look back at that common law rule. When we say that no man should be a judge in his own case, what we're saying is that he should not have a direct interest in the outcome of that case. Now, what's an interest in the outcome of a case? Well, it means that you will be directly affected by the ruling in that case. It doesn't just mean that you'll like the outcome of a case or that you'll dislike the outcome of a case. So judges are allowed to have their own opinions. They can have opinions that crime is terrible, criminals are the worst people in the world, and I think all of them should have the book thrown at them. That's fine. They can have that opinion, and they can still hear criminal cases because that's just something that benefits them sheerly by virtue of the fact that there's some kind of they enjoy the ruling in that case. It creates a society they think is better. Well, there's nothing wrong with judges getting a society that they think is better from their rulings. I think, as I've said before, judges should be able to rule even against what their personal preferences are, but they are certainly allowed to have personal preferences, and sometimes cases are going to line up with those. What we don't want is for judges to rule on cases where the direct effect of that judgment changes their material circumstances. So, they have a right they would otherwise not have if they rule a particular way on a case. Or they lose a particular right they would otherwise have if they rule the other way on the case. So that's what we want to be looking for when we're looking for issues that are that constitutionally require a judge to be disqualified. I mean, think about it. If we had this other rule that mere personal bias or prejudice is sufficient to make somebody have to be disqualified, that would bring into question probably every single kind of administrative court, Article II court. So what's an Article II court? Well, those are courts that are run by executive agencies under the president's authority. They'd be things like the tax courts or EEOC proceedings, things of that nature. Well, presumably every single person that works for the EEOC is somebody, that's the Equal Employment Opportunity Commission, but presumably everybody who works for that agency is somebody who cares about equal opportunity in employment, right? They're people who don't like discrimination at the workplace. Well, the EEOC hears a lot of claims that pertain to discrimination, and the people hearing those claims are employees of the EEOC. So if we were to apply the broader rule that any kind of personal interest or personal bias or prejudice are sufficient to impose a constitutional requirement of disqualification, we'd be having people disqualified all over the place. We probably couldn't even have administrative courts at all, which might not be such a bad thing. I think a lot of those courts have illegally delegated congressional power under the Constitution. That's Chevron deference and all that. We can get into that in a different video if you guys are interested in hearing about it. But suffice it to say, that can't be the rule because we have all kinds of courts right now that would be violating that rule. Similarly, IRS. IRS has an interest in collecting your taxes. They adjudicate matters pertaining to taxes. Presumably everybody who works for the IRS thinks that collecting taxes is a good thing. Maybe not, I don't know. I don't know the psychology of the average IRS member, but presumably, you believe at least somewhat in the mission of what your employer is doing, yet we allow them to adjudicate those cases. So rightly or wrongly, whether or not those tribunals should exist, that obviously can't be the law because it would provide for their non-existence. Okay, so that's sort of the basic rule. Basic rule is about a direct relation to a pecuniary interest that a person has, with a few exceptions, usually relating to usually relating to criminal law. Gosh, I'm all tongue-tied today. Anyway, this was expanded substantially in the case Caperton v. A.T. Massey Cole in the year 2009. So what happened in this case? Well, a party in the case of the lower, so when things go to the Supreme Court, they're usually appealed from lower court decisions. So you had a court already hear something before, and there's a ruling on that case. I think most of you guys probably know that. But in that case, there was a lower court that had heard a case in which a party to that case had been a substantial campaign contributor to the judge hearing that case when that judge was initially being elected. Because judges in most states run in elections, people vote for them, they can get campaign contributions. So one of the parties in this case had contributed to his campaign. And I think it was something like $3 million he contributed to the campaign. It was a substantial amount. Well, the Supreme Court in this case, I think it was a 5-4 ruling, with Justice Kennedy as the swing vote on that case, ruled that the judge was required to recuse himself, and they remanded the case back to the lower court to be heard again with a different judge. Now, you might be thinking, again, that's a pecuniary interest the judge had, because that party, that person who was party to the case was somebody who contributed $3 million to his campaign. Yes, but remember, it needs to be a pecuniary interest in the case, historically, for constitutional and common law rules to apply. Was that true here? Well, no, because the $3 million was money that he had received in the past. He was not going to lose that $3 million if he ruled a particular way in this case. You could say, now this guy's not going to contribute to his next election campaign. And that might be true, but again, that's not a consequence of the case itself. He's not, as a result of the ruling, deriving a financial benefit or incurring a financial harm. But the Supreme Court, nevertheless, in a 5-4 ruling, did say that that judge was required to recuse himself. Now, this substantially broadens the standard for judicial recusal or judicial disqualification. What the court looked at in this case was instead whether or not the probability of actual bias on the part of a judge or decision maker was, quote unquote, too high to be constitutionally tolerable. They borrowed this language from dicta in the case Withrow v. Larkin. It's a 1975 case. But that language was not controlling in that case. The first time it became controlling was in this 2009 Caperton case. Still, even under this standard, the court did specify that the interest may not be indirect or remote. So it's still got to be a direct interest that would give a high probability of actual bias on the part of the judge. But we've switched the standard from, remember what that common law rule was for centuries, actually deriving a material benefit from a case or detriment from a case, to now whether or not there is a high probability of bias. Well, what's the problem with that? I mean, that seems like that makes a lot of sense, right? If the judge can be biased on something, you ought to make them recuse themselves. Well, the problem with that, and it's addressed by both Justice Roberts and Justice Scalia in the dissenting opinions in that case, is that there's no clear line for what constitutes conduct worthy of disqualification. Now, previously, you could look at a case and you could see exactly what qualified as conduct that would get someone disqualified. Now we just don't know. And the court actually explicitly recognized this, citing the Lavery case. And they said the probability of bias, quote unquote, cannot be defined with much precision. All right. That makes it hard to adjudicate, doesn't it? And opposing the dissenting opinions in that case pointed to the fact it's probably going to proliferate a whole lot more litigation on this issue, because now pretty much everybody's going to have a claim that the judge is interested in the case. As Scalia pointed out, you're going to have people, lawyers, paid billable hours to comb through pages of documents just to see what kind of campaign contributions people received. Well, I don't know that that's happened. There haven't been a whole lot more Supreme Court cases on the issue of judicial disqualification since then, but it's certainly a risk. And as long as that's the way the law stands, those are challenges that can be brought by lawyers. And I have one I'm going to tell you about toward the end of this video that we are considering bringing. And it's great because, either way we win. Either we get the standards for judicial recusal contracted, or we win our case on the merits. So, I'm not going to complain about that. Anyway, the rules that I've just articulated, to be clear, Caperton is now controlling law. Technically, it's controlling law on the issue of judicial disqualification, although it has not been applied that much, and it's kind of, in my opinion, at odds with the historical direction on judicial disqualification cases. But the rules that are articulated in the Caperton case are the constitutional limit. Well, what does that mean? That means that no matter what kind of law federal government has in place, or any of the states have in place, a judge cannot participate in a case if he is biased to the degree addressed in the Caperton case. jurisdictions are perfectly free to set their own qualifications in excess of this. So if they want to say, a judge can't have any interest in, can't have any probability of bias on a case, even if it's very, very remote, they could theoretically pass a law that says that. In fact, the United States Code says that a judge shall disqualify himself in any proceeding in which he is, says a judge may disqualify himself in any proceeding in which his impartiality might reasonably be questioned. So again, that's a more restrictive standard than what the Constitution necessitates. Nearly every state has incorporated the American Bar Association rule that a judge shall avoid impropriety in the appearance of impropriety. Again, more restrictive than what the Constitution requires. I'm just saying, what the constitutional requirement for judicial recusal is. Significantly, the federal rule on that also includes personal bias and prejudice or personal knowledge of any disputed evidentiary facts. I think that personal knowledge of disputed evidentiary facts would probably be incorporated under the common law rule as well. That's not so much related to recusal as a result of bias as it is just recusal because you're not suited to be judge in this case. You're literally not... You are not hearing the facts as presented to you. You have your own independent assessment of those facts based on your knowledge outside of court. It would be very hard to put that to the side. Okay, so now we know what the rules are when it pertains to judicial disqualification. Next question is, what's the remedy? What happens when a judge doesn't recuse himself when he's supposed to? Well, first of all, it's exactly what happened in the cases I just mentioned. The case is remanded to the lower court that initially heard it, where it will then be heard by a different judge and a new verdict will be rendered. This is complicated somewhat, obviously, by the idea of Supreme Court justices and whether or not they recuse themselves. Why is it complicated? Well, because the Supreme Court is the court of highest appeal. If a Supreme Court justice refuses to recuse himself, where do you go? There's nobody above him. He's the boss. There's no judge that's higher than a Supreme Court justice. So what do you do when a Supreme Court justice refuses to recuse himself? Well, there are, in Article 3 of the Constitution, does provide grounds for judicial impeachment. And it says that justices of the Supreme Court will serve for good behavior. So presumably refusal to recuse yourself consistent with the Constitution would constitute bad behavior, and you could remove a justice for that. So that's a theoretical remedy. I don't know, I might be wrong here. If I am, somebody correct me in the comments, but I don't know that that's ever happened in our history. I don't think any Supreme Court justice has ever been impeached because they failed to recuse themselves from a matter in which they had an interest. That may have been the claim on some of them, but I can't think of any where that was, in those cases it was really pretty political and the reasons they were impeached, but I can't think of any case where that was actually the reason why a judge was impeached. But we do have a lot of history about judges who have recused themselves from cases. Famously, probably the most famous example is going to be John Marshall in the 1813 case, Martin versus Hunter's Lessee. It's a very famous case. You read that, probably every first-year law school in America reads that case. And the reason that Justice Marshall recused himself from that one is that he had actually contracted to buy the land that was in dispute in the case. So, clearly you can see what his pecuniary interest is in that. If he rules for one party, he's saying he doesn't get the land. Well, if he rules for the other one, maybe he's saying that he does. Sandra Day O'Connor in more recent years would commonly recuse herself from cases that involved telecommunication companies because she was heavily invested in the telecom sector and she didn't want suggestions of bias there because, again, you rule in favor of a telecom company, you are letting telecom companies keep more money, which makes their stocks more valuable. So she's deriving a direct financial benefit from that. Justice Breyer, I think, would also recuse himself less often, but somewhat regularly from cases that involved insurance companies, because he used to work for work with at least Lloyd's of London, which is an insurance company. Even Clarence Thomas, in past cases, he actually recused himself from a case involving the Virginia Military Institute because at the time his son was a student there. When have judges not recused themselves when they probably should have? Well, the most famous instance that comes to mind for that, and I'm not voicing my opinion on what he should have done, but certainly many people claim that he should have, is the late Justice Hugo Black, when he refused to recuse himself from the Jewel Ridge coal case. in which his former law partner was actually the attorney for one side. And this got him in a huge fight with Justice Frankfurter, and they think eventually may have led to the Chief Justice's death because of all the infighting in the court that occurred over this refusal of Hugo Black to recuse himself. Was he required to do so? That's not what I'm saying. In fact, I'm not saying in any of the instances where justices did recuse themselves, I am not saying they were required to do so. And in any of the ones where they didn't, I'm not saying they weren't required to do so. A lot of times a judge will recuse themselves out of sort of courtesy. They don't want people to think that the justice system is horribly biased, horribly corrupt. And that's why they'll recuse themselves, even when the Constitution may not require them to do so. And that's fair, that makes sense. I just don't want you to infer from the cases that I've cited that these are sort of the standards under which judges must recuse themselves. There's a lot of misunderstanding about the idea of precedent, I've found in my conversations with people. Precedent doesn't just mean something, legal precedent. So we know that obviously in the American legal context, Anglo-American legal context, our law is the result of precedent. So past rulings bind future rulings. We call this the rule of stare decisis, or let the decision stand. And there's some confusion about the idea of precedent with people thinking that anything that a court has done in the past or anything that a judge has done in the past must be binding precedent. That's not true. Rulings are binding. So when a court issues a ruling, when it finds actual factual or legal findings about something, that binds courts within the same jurisdiction or under that court's jurisdiction. So we can get more into jurisdictional stuff in a different video if you guys are interested in that. But just to clarify, none of these cases I've cited are binding precedent because they're just things that judges decided to do sua sponte, or on their own initiative. Now, finally, this brings us to, what time are we? 32 minutes, gosh. This brings us to Ginny Thomas. Okay, so again, as I mentioned earlier, the case that gave rise to this controversy is going to be the Texas v. Pennsylvania case, which was part of President Donald Trump's election challenges with respect to the 2020 election. I was actually heavily involved in that case when the court was hearing that on behalf of the president in his capacity as a candidate at the time. So this is something I know a lot about. But all that to say, Ginny Thomas is a close relative of Clarence Thomas, obviously. She's his wife. So there is a close connection there. That part is satisfied. Now let's look at whether or not the interest, or whether or not there is an interest, or whether or not that interest is one that would give rise to disqualification. Well, Ginny Thomas is not a party to the case. Obviously, it's Texas v. Pennsylvania, and a few other states, Georgia, Arizona, and the rest of them. So she's not a party to that case. Does she stand to derive some kind of material benefit from that case? Is it as though she's a party to the case? Well, not really. She certainly is not directly financially helped by a ruling in President Trump's favor. And she's not really harmed by a finding against President Trump. You can see that she obviously has very strong political opinions, but as I mentioned earlier, judges are allowed to have opinions, and certainly if judges are allowed to have opinions, their spouses are allowed to have them too. And they are allowed to voice those opinions. Now, it may be, I don't know if this is true or not, I know it was Representative Ocasio-Cortez who brought up the idea of I guess, impeaching Clarence Thomas. So maybe she was thinking that, when Ginny Thomas sent these text messages, she's the reason why the president continued to prosecute these claims in court. Maybe she was the mastermind behind all of it. I don't know that that's particularly credible. I don't even know that she's claiming that. If she were claiming that, I don't know, maybe, but that doesn't seem terribly credible to me. Now, you're sort of moving on with it. There's also no direct connection to Clarence Thomas with respect to the matters at issue in this case. So I think part of the misunderstanding that Representative Ocasio-Cortez has is to assume that this case was going to decide who the next president is going to be. Well, that was not the issue that was addressed in that case. That case had to do with several states that had refused or allegedly refused to enforce their election laws, or in which legislatures had in my view and in the view of the litigants in that case, unconstitutionally delegated their power to executive agents, usually Secretary of State. It wasn't really about who won the election. It wasn't really about widespread fraud. Those just weren't the principal issues in that case. So, frankly, Ginny Thomas's text messages aren't really even on point for the case that Representative Ocasio-Cortez is saying Clarence Thomas should recuse himself from. Now, there is, so that sort of, I think that answers the question about Clarence Thomas's recusal, whether or not he ought to have recused himself from that case. I don't think so. Obviously Ginny Thomas is his close relative, but he didn't have any interest in the outcome of that case. She didn't really even have any interest in the outcome of that case, apart from just her political opinions. I think really they're just trying to do sort of a guilt by association thing. The fact that she was in support of things that were tangentially related to some of the violent events of January 6th means that she's now a very bad person. So her husband must also be a very bad person and should be removed from the court. Maybe that's a cynical view, but that's sort of what I think is going on. I don't think there's really any credible argument here that Justice Thomas should have recused himself. But that is the issue on that. Now, I want to show one last text message from Ginny Thomas. So she says, Biden, crime family, and ballot. So I think this first part is a quote, or at least a summary of something from some kind of, well, probably fringe, maybe not fringe, but some kind of right-wing news source that doesn't do its research too well. And it says, Biden, crime family, and ballot fraud co-conspirators, elected officials, bureaucrats, social media censorship mongers, fake stream media reporters, etc., are being arrested and detained for ballot fraud right now and over coming days, and will be living in parches off Gitmo to face military tribunals for sedition. And then she follows us up with, I hope this is true. Now, both Ginny Thomas and Clarence Thomas, I believe, have claimed that they don't really talk about the matters that are before the Supreme Court. And if this text message is any indication, I absolutely believe them, because there is no way this is happening under American constitutional law. I'm not going to even get into the problems with this text, but this is not true. This was never happening. This hopefully would never happen in America. We have some pretty unfair trials, and we definitely have some administrative targeting or law enforcement targeting of individuals who are deemed to be a threat or even political opponents of some of the people in office. But we don't try them in military trials if they're not members of the military. That just hasn't happened. And that was one of the use of the Admiralty courts was one of the principal causes for America writing the Declaration of Independence and separating from Britain. I don't think that we're going to start doing that real soon to our civilian population. All that to say, I don't want to make fun of Ginny Thomas here, but I'm not sure that she's that up on the legal issues involved here. If this is any indication of the degree to which Clarence Thomas and she talk about legal matters, I don't think we have anything to worry about in terms of them influencing one another on these things, because this just isn't happening. Okay, so that sort of concludes what I have to say about Clarence Thomas and Ginny Thomas, whether or not he should recuse himself from the case. I mentioned earlier that I would talk about a case that Lex Rex is potentially bringing in the near future. Well, Los Angeles County currently has a rule in place affecting judges, saying that any judge who misses work on account of contracting COVID-19 at a public event is given leave without pay. So in other words, they will not be paid if they contract COVID-19 at an event. Well, obviously, as you'd imagine, judges are hearing a lot of cases pertaining to the COVID-19 pandemic right now. And, in my opinion, if you look back at the rules from the Caperton case that I mentioned earlier about, whether or not there's a substantial probability of bias on the part of a judge, well, judges really don't want to contract COVID-19, especially at public events, and I imagine they probably want to go to public events. They don't like being cooped up any more than the rest of us. Well, they now derive a direct financial pecuniary harm from contracting COVID-19 at those sorts of events. So I would say that there's certainly a high probability that they would have a bias on cases that relate to required vaccinations, if they believe vaccinations prevent spread of the virus or even inhibit spread of the virus, or cases that pertain to other things that have to do with COVID-19 liability. Now, because the courts are so behind right now on their schedule, we've pretty much only had preliminary motions, TROs, preliminary injunctions, those sorts of things heard at this point. But eventually those trials will be heard in the future, a year or two from now. Well, when they're heard, if we end up losing any of those cases, I think we've got pretty strong grounds to allege judicial misconduct, don't you think? Or not, if not misconduct, certainly judicial bias, requiring the judges to disqualify themselves. Well, it's worth a thought anyway, and as I mentioned earlier, if we win on these cases, well, that means that we get to have our cases reheard, and if we lose on these cases, well, then theoretically it could get appealed all the way up to the Supreme Court, and we could get a revisitation of those Caperton rules, which would also be a good thing. So it seems like a win-win to me. We're certainly going to bring those cases in the future if we think that there are circumstances giving rise to them. So keep your eyes open for that. Those will be cases that require quite a great deal of funding, since there's a lot of law in motion involved on that, which requires a lot of attorneys' hours, and the attorneys that work for me do like to be paid. I've tried to get them to compromise on that point. Actually, a lot of them have. We have a lot of attorneys donating their time pro bono, but a lot of them still like to be paid. So we could use contributions for those cases. If that's something that you feel moved to donate to, please do that. You can donate on our website. That's lexrex.org/donate. That sort of concludes my Ask an Attorney question for today. Oh, one other. Actually, I'll mention another case too, just because it's amusing. A few years back, California Supreme Court heard a case that related to the public employee pensions. And they were told by opposing counsel in that case that their pensions would be affected by a ruling that these pensions were unconstitutional, which I think probably would have been the correct ruling on that case. Should they have been disqualified from that case? Well, in my opinion, no, because it wasn't true. Their pensions would not actually have been affected. So, they may have bought it anyway. They did rule against, the side that I think was correct on that case. But that's just another sort of anecdote. That actually concludes my Ask an Attorney question for today. Now that we're 42 minutes into this, I apologize for the length. See if we can cut something out of it later before we post. Yeah. All right. Well, thank you for sticking around. If you have any questions you want to ask in the future, you can ask in the comments on this video, or you can submit them by email, or you can I've said in the past, Pony Express, mail, however you want to send them to us. We will answer those questions. So yeah, thank you for listening. And this has been a presentation of the Lex Rex Institute.